We just get so excited around here. All right. Well, good morning, everyone, and welcome once again to Talkback for this Monday edition, 1 hour edition, brought to you by Bulls Eyewear, Missoula's only certified master optician on South Reserve of the old R.P. Ellis location. 552-1299, online at bullseyemt.com. Also brought to you by Selway Armory on Stockyard Road, Montana's premier firearms dealer. And Dig It Excavating, where they bring 30 years of excellence to every job. 214-4292. And one more brought to you by First Montana Bank, your home for free Centennial checking and unlimited cash back every time you use your debit card. Okay, here we are, ladies and gentlemen, on Talkback this morning, and we are thrilled to have with us on the telephone Rob Natelson from the Independence Institute in Denver, Colorado. Rob, good morning and welcome once again, sir.
Good morning, guys. How are you?
Fantastic.
Yeah, it's been a couple busy weeks. I understand that we have something pretty historic going on in Arizona that you have something to do with. Tell us a little bit about what's going on down there.
Well, the bottom line is that Arizona has just called the first national convention of states in over 150 years. At the end of February, I went down to Arizona at the request of some folks there to talk to members of their legislature. And it was clear when I was there they were very interested in triggering the Article 5 amendment procedure, but they needed some additional information. After I got back, they passed the application for a balanced budget amendment. They became the 29th state to do so. There are 34 necessary. They also passed the more sweeping applications, the so-called Convention of States application. And then they did something that was unexpected. We kind of expected the Tennessee legislature would do it, but Arizona beat them to the punch. They called a planning convention of the states for September 12th. This has not yet been reported in the national media. This planning convention would be, as I mentioned, the first formal convention of the states on a national level. We've had regional ones, but on a national level, the first one since 1861. And its purpose would be to plan for a balanced budget convention when it occurred. So, for example, they would craft rules for the convention, get to know each other, recommend to Congress where a convention could be held, and so forth. It's a way of refreshing some of the historical knowledge that had been lost since it's been so long since we've had a convention.
What happened in 1861?
In 1861, Virginia called a convention of the states in order to craft a constitutional amendment to try to head off the Civil War. The convention met for 3 weeks in February of 1861. It was the largest convention of states ever held. They pounded together a constitutional amendment. But because they weren't an Article 5 convention, in other words, they didn't have formal constitutional sanction, they couldn't just have the states ratify it. They had to recommend it to Congress, which did nothing, and the compromise was never adopted. The Civil War broke out. But the convention itself, which met in very difficult circumstances, was still a success in that it did produce a constitutional amendment. It's called the Washington Conference Convention of 1861, and its nickname is the Washington Peace Conference.
Wow. Those are words that probably are they're kind of an oxymoronic these days.
The Washington Peace Conference?
Yes, because there's very little peace in Washington.
Virginia, many southern states had already seceded. Virginia had not seceded, and they wanted to stay in the Union. They wanted to find a formula by which they could stay in a Union. One of the interesting things, a little bit of trivia here, is that there have been at least 3 conventions of states where present or future presidents of the United States have presided. At the Constitutional Convention, Washington presided. He was not yet president. At the Regional Convention, which drafted the Colorado River Compact, Secretary of Commerce Herbert Hoover, a future president, presided. And at the Washington Peace Conference, John Tyler, the former president, presided.
Wow, interesting links there. So
this Convention of States thing is a very, has a major role in American history. And I kind of laugh when people say, there are no precedents for it, or we don't know what the rules are. It's really absurd. We've identified over 40 of them so far.
I'm curious, what does Montana play any role in all this? We have an odd legislature cycle with the 2-year biennium.
Yeah.
Because
the Montana legislature, I don't believe Montana has ever participated in a convention of states. Other Western states have, including Colorado, in at least 3. But Montana, I believe, has not. However, the invitation that just went out from the Arizona legislature is going to be extended to all the states. And so if Montana wants a seat at the table, what's going to have to happen is the Montana legislature will have to authorize participation and send commissioners. And again, it will be meeting in Phoenix on September 12th. I don't expect that they're going to get anywhere near all the states to cooperate, but if they get a reasonable handful, they can negotiate some rules and basically, familiarize people with the working procedure.
I was going to ask you, Rob, what has been the interest so far, considering the fact there's been a terrible lack of publicity about this?
Well, it only happened on Thursday.
Oh, okay. Gotcha.
The invitation was on Thursday, and the Arizona legislature hasn't even issued a press release announcing it yet.
No.
So, you are really getting the news first here on KGVO.
As of course we always do. This is no surprise. I'm really curious, though,
Rob.
One
more example.
So one legislature in one state makes this call.
Sure.
Does there have to be a response, or does this mean for sure something happens?
Okay. A call is just an invitation. Traditionally, most conventions of states have resulted from a call by one state. The Constitutional Convention was called by Virginia, for example. There's a myth out there that the Constitutional Convention was called by Congress and limited by Congress. That's not true. It was called on December 1, 1786 by the state of Virginia. Similarly, the Annapolis Convention and the Washington Convention of 1861 were all called by Virginia. The convention that negotiated the Colorado River Compact was called by Colorado. The convention that so-called antitrust convention, it was called in St. Louis in 1889, was called by Kansas. So any state can call a convention. However, the Constitution says that only Congress may call the convention for proposing amendments, but Congress must do it once two-thirds of the states tell it to.
Okay, gotcha. So they need 2/3 of the states.
Right, that's 34.
And how do they respond? Do they RSVP? They send their birthday party card back in the mail, or what?
They don't have to do anything other. The way they respond, they don't have to send anything back to Congress. The way they respond is simply by passing a legislative resolution saying we're going to participate and appointing their representatives, who are called commissioners, and then the commissioners meet, and Congress is really out of it at that point until an actual amendment is proposed. Then the only role Congress plays after that is, as with any amendment, they choose whether ratification is going to be by state legislatures or state conventions.
Okay.
So it's really a state-driven process. This is a way designed as a way to get around Congress. Now, the meeting that has been called by the Arizona legislature is not an Article 5 convention. It is a planning meeting. And we've had a number of those in our history, too. That's basically what the Annapolis Convention of 1786 turned out to be, was a planning meeting.
Okay, we've got to take a break. We'll be right back. We have 3 lines open if you'd like to visit with Rob Natelson, getting some breaking news here, quite literally all about the Constitution. So give us a call at 721-1290. We'll return with more of Rob Natelson in a moment. And we're back on Talkback, joining the Independence Institute. And we're just talking about some very interesting news regarding a get-together of the states dealing with the Constitution. So go ahead.
Yeah, there was some other breaking news recently. I have a clip in our sound system here, Peter, if you want to play it. This is Senator John Tester. He was asked by MTN News correspondent Mike Dennison from KPAX just kind of about what's going on as far as his position on whether or not Neil Gorsuch should be put into position on the Supreme Court. Also, whether or not they would try to filibuster Mr. Gorsuch. And here's what Mr. Tester said.
Here we go.
Judge Gorsuch thinks that corporations are people. I don't think that's where Montanans are. Judge Gorsuch thinks that the government should be in between a woman and her health care decisions. I don't think that's where Montanans are. And Judge Gorsuch thinks that we ought to be extending the president's ability to snoop on people and invade their privacy. I do not think that's what the Constitution says, by the way, and I don't think that's where Montanans are.
All right, so there you have it. That's our Senator Tester. I had another clip I wanted to play. This is from Patrick Leahy sounding completely sober during his interview with Mr. Neil Gorsuch on the floor.
Now, here we go.
In contrast to past nominees like John Roberts, whose judicial philosophy was not clearly articulated when he appeared before this committee, Judge Gorsuch appears to have a comprehensive originalist philosophy. The approach taken by jurists such as Justice Scalia, Justice Thomas, former Judge Bork. While it has gained some popularity within conservative circles, originalism, I believe, remains outside the mainstream of modern constitutional jurisprudence. It's been 25 years since an originalist has been nominated to the Supreme Court. Given what we've seen from Justice Scalia and Justice Thomas and Judge Gorsuch's own record, I worry that it goes beyond being a philosophy and it becomes an agenda. We know that conservative groups that vetted Judge Gorsuch and the millionaires who fund them have a clear agenda. One that's anti-choice, anti-environment, pro-corporate. And these groups are obviously confident that Judge Gorsuch shares their agenda. The first person to interview Judge Gorsuch in this process explained these groups did not ask who's a really smart lawyer who's been really accomplished. Instead, they saw a nominee who understands these things like we do. After all, Judge Gorsuch has been described by a former leader of the Republican Party as a true loyalist and a good, strong conservative.
All right, there you go. So you get a little bit of a taste. John Tester really opposing Gorsuch, it sounds like, because he disagrees with Mr. Gorsuch on some, policy issues, and not necessarily interpretation issues, except for he does disagree with him on the idea of corporations and their definition. And then Mr. Leahy going straight to the heart of interpretation of the Constitution, saying that the quote-unquote originalist view is out of the mainstream. I wanted to get your take on things there, Rob. Obviously, this is a little bit of your bailiwick, this whole originalism discussion, since you wrote the book, The Original Constitution, what it actually said and meant.
Well, first, you recall that when this election campaign was going on, one of the things I said is that it's the worst nightmare of a lot of people in Congress to have originalists on the court. That the only real difference was going to be made as to whether they were originalist or non-originalist. It wouldn't matter otherwise whether a Democratic or Republican president appointed them so much. And I said that the Democrats would go to the mat, that they would filibuster any originalist nominee, and this demonstrates it. I mean, you can't come up with hardly anybody who is more personable, who has been more reasonably restrained, more inclusive than Judge Gorsuch, but simply because he's an originalist, they're going to filibuster him. The issue as to originalism being out of the mainstream is very interesting, since I believe that Senator Leahy voted for Justice Sotomayor, who in hearings described herself as an originalist. Whether she really is or not, I don't know, but she certainly described herself as one. But more important here is that originalism is proper interpretation of legal documents. Everybody is an originalist. All judges are originalists with every single document out there except the Constitution. When statutes are interpreted, they try to look for the original meaning or the original understanding behind the statute. When contracts are interpreted, they look for the original understanding behind the contract. When the Montana Constitution is interpreted, the Montana Supreme Court looks for the original intent behind the Montana Constitution. It's only in the area of the U.S. Constitution that some judges and law professors change ground and for conveniency purposes throw out the interpretive technique that they use for every single document, the interpretive technique that the founders themselves would have applied and say, well, we're not going to do that. And the reason they don't do that is clear. The original Constitution controls Congress's power in ways that Congress and certain apologists for Congress and for the status quo don't want to happen. They don't want to see those limits on Congress's power. Fundamentally, for these people, I believe issues like abortion are peripheral. In other words, I don't think issues like abortion are peripheral for many constituencies, but I think for the people in Congress, they really are. They're just using that. What they're really concerned about is that the Supreme Court might say one day, hey, Congress, you can't pass that law that's outside your enumerated powers. There's nothing that they want to see less.
Well, it's a lot easier to be a make-it-up-as-you-goist than to be a originalist.
Of course. What they've done is they've largely changed our Constitution into the Constitution we rebelled against in 1776. 1776, the British Constitution, the British political system, unwritten Constitution, ultimately changeable by the politicians anytime they want to if they try hard enough. And that's what they've done to a large part to the American Constitution. They've overturned the American Revolution and changed us to a so-called living Constitution, by which they mean a Constitution that the politicians can change any way they darn well please.
Yeah, with that, we're up against another break, and I'm thinking of going to my bank and asking that my mortgage be considered a living document as well. So,
well, they will interpret it that way. It's just going to go not in your favor.
A liberal judge would apply a liberal, a living version to your mortgage or to any other legal document. They apply it only to the Constitution. So who's out of the mainstream here?
Right. We're going to be right back. We have Ruth waiting on the line to visit with Rob Natelson. We have two other lines open. 721-1290 is our number, and we'll be right back. Hey, we're back on Talkback. 721-1290 is the number. Joining us on the phone is Rob Natelson from the Independence Institute. Go, John.
As usual, Rob is a rock star, and we have all the phone lines full already. Actually, one's open, 721-1290. We just left off. But I do have some Facebook I want to get through on the Gorsuch nomination fight. Brenda says, Tester said appointing Gorsuch would not be representing Montana values. I'm a fourth-generation Montanan, and Tester does not represent my values. I'm so sick of the insanity from the Democratic Party. And Dylan responds with, I think, an interesting question for Rob from a historical perspective. He says, yeah, Republicans would never block a SCOTUS nominee. Not never, no way, especially not at all last year, referring to the delay on the appointment from Obama. So, Rob, which party is out of whack here? Are we all out of whack? Is Neil Gorsuch getting the bad end of the stick, or were prior nominees treated just as poorly?
Well, let me answer it on two levels. First, I mentioned to you that the Democrats would filibuster any originalist nominee, right? They want Trump to nominate someone like John Paul Stevens, who's basically going to join their agenda. Because we have not had a court with an originalist majority is the reason why we have this partisanship that's going on. You notice that some of the objections against Gorsuch had nothing to do with the law or the Constitution or the way that he interpreted either exactly. Some of them simply had to do with, he didn't reach the right result. I don't think that corporations are people, said Senator Tester. The court, because it is not an originalist court, has injected itself into just about every controversy in American life. And in doing so, it's created a situation where every nominee is extremely high stakes. That's why you see these tremendous fights over these nominees and this extreme partisanship. You get a court full of originalists who keep the federal government down to the size it's supposed to be. You'll see these battles go on in politics, but you won't see them going on over court nominees, because then it will simply be a matter of who interprets the law better.
Okay, let's get to the phones. Ruth, you are on with Rob Natelson. Go ahead.
Well, hi. Thanks for taking my call. I have a question and then a perspective that I'm wondering if you, Rob, would clear up for me. My question, again, is the sanctuary cities just nagged the heck out of me. When somebody is refusing to uphold federal law, like if our governor were to say that he's not going to do any background checks for gun sales, I can imagine people like ACLU and stuff would come racing in to fight that. Who helps us fight things like mayors or governors making sanctuary cities and sanctuary states? How do we stop them from doing that illegal activity? And then the perspective that I had, that I was wondering if you would clarify, is what little studying I've done on the Constitution, and then trying to say that the original doesn't fit with today's time. What I understand is our founding fathers really understood human nature, and that is always relevant. And I'll shut up. Thanks.
Okay.
Thank you, Ruth.
First, on the sanctuary cities issue, I'm really amused by this because I remember during the 1990s when I was advising a committee of the Montana legislature, we were called extremists for suggesting that the state should resist unconstitutional federal overreach. Well, here you have some of those same people resisting unquestionably legitimate federal laws. It's the federal government that's given primary control over foreign affairs, including immigration. And so you've got these same people refusing to enforce laws that are unquestionably constitutional. As to answer the question as to what the most effective way of responding is, I think the idea of cutting off federal funding is a good idea. I say that for two reasons. One, it's likely to work, and secondly, because it will be an instructive lesson to our friends on the left of the risks of federal funding to local control.
But hold on, Rob. Will the threat of removing federal funding simply send these cities and states running to their favorite federal court? The judge was probably appointed by President Obama, and he will basically put a block on it saying you can't do that, and that everything grinds to a halt.
The U.S. Supreme Court has final say in this matter, and this is one area where they've acknowledged that the federal government has very broad discretion as to federal funding. For example, a number of years ago, state universities tried to impose bans on federal ROTC activity on state university campuses and other public campuses. And so the federal government responded with a cutting off of funding, and that cutting off of funding was upheld by the U.S. Supreme Court 9-0.
Wow.
It was the first major decision issued during Chief Justice Roberts' tenure. So the court's been pretty strict on that. I'd argue maybe even too strict, but it's a very, very potent weapon. Now, the other question that the caller raised regarding, the founders knew about human nature, and they tried to incorporate human nature into the Constitution. That's true. But they also knew how to write a Constitution that was strict where it needed to be strict, flexible where it needed to be flexible, and somewhere in between where it needed to be in between. So you've got flexible language like reasonable, and strict language like 4 years, and language in between like necessary and proper. When you interpret the Constitution from an originalist standpoint, there's quite a bit of play in the joints there, much more than a lot of people acknowledge, but just not as much as people in Congress want. If there is a feeling that the Constitution needs to be changed, and that's a genuine feeling grounded in reality, then of course we've got the amendment process. What's really going on is that people want to keep originalists off the Supreme Court so that the politicians can surreptitiously change the Constitution to their liking without the amendment process.
Okay, we're going to take another break. Alan and Dave are both waiting to visit with you, and we have one line open for Rob Natelson, 721-1290. Welcome back to Talkback. 721-1290 is our number. We have one line still open. Rob Natelson joining us from the Independence Institute in Denver. And go ahead.
Yeah, Rob, you had a comment you wanted to make?
Yeah, it was a comment regarding the audio that you played from Senator Tester, in which he said that one reason he was going to vote against Gorsuch was that he didn't believe that corporations were people, etc. What that is code language for is that he wants, as a member of Congress, much broader power to pass laws governing the campaigns by which members of Congress are challenged. In other words, members of Congress want to control congressional campaigns because they want to, disadvantage challengers.
They want to win.
It's an excellent illustration of my point that the reason that guys like Tester don't want originalists on the court is it's really all about power, their own power, the power of Congress. It's not about what they would probably consider peripheral issues like abortion.
All right. Now, so when someone says corporations aren't people, what you've talked about this before. What is a good, maybe 2-sentence answer we can say to people? Hey, this is why the Supreme Court voted in this manner.
By the way, we're talking about Citizens United.
One quick answer is, if they're not people, what are they, giraffes? I mean, corporations are groups of people. They're teams of people, just like partnerships are and unincorporated associations are. Furthermore, look at the First Amendment. The First Amendment says Congress should make the law infringing freedom of speech. It doesn't say freedom of speech of this person or that. It says the freedom of speech. That includes everybody, whether you happen to be organized in an association and whether that association happens to be incorporated or not.
Well, and that's the thing that you can bring up, too, is the dangers of treating corporations as if they're not people. If you start treating corporations, like most newspapers are, not like people, and you stop allowing them to have the rights that are given out to people, like freedom of speech, things like that, you can see how this can quickly go down a dark path.
Yeah, is the New York Times, for example, the New York Times is incorporated, right?
Right.
The New York Times, are they to strip from the New York Times the freedom of the press? I mean, that's the implication of what Tester is saying. In fact, I think somebody ought to ask him that in a town hall meeting. That is to say, if you don't think that corporations are protected by the First Amendment, does that mean that you believe in stripping freedom of the press from every incorporated newspaper in the country? Because that's an effect of what he is what he's saying.
Okay, let's get to the phones. Alan, you are on Talkback. I'm sorry. Just a minute. I got the wrong one. Alan, you're on Talkback. Go ahead.
Yeah, good morning, Rob.
Good morning, Alan.
I believe that what's happened in this country is we have lost an understanding of what a constitution really is. I've got a quote from Thomas Paine that I think really establishes what a constitution is and the role it plays, and I would like to read it to you and see what you think. A constitution defines and limits the power of the government it creates. It therefore follows as a natural and also logical result that the governmental exercise of any power not authorized by the Constitution is an assumed power and therefore illegal. And I think that really summarizes the Constitution.
I would say it summarizes a written Constitution, because as you know, there's an older meaning of the word Constitution, which was still used during the founding era to mean the general political system, like we talk about the British unwritten Constitution. But I think it is a good definition of a written Constitution.
Thanks, Alan.
When somebody like Chuck Schumer, for example, negotiates the passage of an unconstitutional law, he undercuts his own legitimacy as a U.S. Senator. He's elected a U.S. Senator by virtue of the U.S. Constitution. He's entitled to engage in legislative activities only by virtue of the U.S. Constitution. If he violates the U.S. Constitution, it's like saying, I'm not legitimate. I have no power. That's an effect of what he's doing.
Okay. Well, I know Dave wants to make a comment, but I want to give him plenty of time to make that comment. So, Dave, if you'll hang on, we'll take a quick commercial break, come right back, and then we'll have Dave on, and John's on the phone with somebody else, and we have one line open for folks who want to visit with Rob Natelson from the Independence Institute. We'll be right back. Talkback. 721-1290 is the number, 1-800-568-5309. Joining us on the phone, Rob Natelson from the Independence Institute. And our monthly visit with Dave, we appreciate. And let's get Dave on the line. Dave, good morning. Thanks for holding. You're on with Rob. Go ahead.
Yeah, good morning.
Hi, Dave.
Good morning. About corporate money. Now, I'm a stockholder in a corporation, but I don't have a voice in telling the company that there's no ability for me to tell the company to stick out of politics, because I'd rather they spend their money outside politics. And so I don't feel like I'm represented within the corporation.
Well, some stockholders have more representation than others, right?
Right.
Especially if you have 51% of the stock.
Right. But there's no mechanism for me to vote to say, no, I don't want my money spent in politics. Whereas
Okay.
I'm also a union member, and I have voted against spending union money in politics.
But that hasn't stopped them, though, has it?
Well, at least I had a chance to vote, and I don't with the corporation.
Is your corporation publicly held? Could you readily sell your stock?
Yes.
Okay. Let me tell you, this is a good teaching moment. There's a difference to the difference between personal preference and the Constitution.
Thanks, Dave.
If I could wave a magic wand, I would say that corporations and labor unions are both economic institutions, and they shouldn't be participating in politics. Okay, that's what I would do as a matter of my policy preference. But there's a difference between that and the Constitution. The First Amendment reads, Congress shall make no law abridging the freedom of speech or of the press. It doesn't say freedom of speech or for the press just for individuals or just for that kind of group or that kind. It's for everyone. So there's a difference between what I would like or what Senator Tester would like and what the Constitution requires. The rule of law to which someone like Neil Gorsuch is attached, the rule of law requires that we apply the Constitution as the Constitution was understood by the people who adopted it. And I think the argument's pretty clear that means that groups, associations of people have the same right to engage in freedom of the press, freedom of speech that individuals do. And by the way, that they've also got a right to anonymity, especially in the area, especially when they're communicating through a medium like the press or like through broadcasting. So it's not necessarily something I would particularly like. Now, let me just answer the question at one other level. If you don't like what a corporation is doing, there are so many options today, if it's a publicly held corporation, to sell your stock at a good price and put your money in somewhere else, that it's really not that much of a hardship. On the other hand, if you've got a corporation which is closely held and that a small group of insiders is controlling it and you're an outsider and you're pretty well stuck in it, then you may very well have a legal claim, a claim that your money is being used improperly in the case of a close corporation. Not because of freedom of speech, but simply because of traditional corporate and fiduciary law.
All right.
Now, but am I wrong here? Isn't the essence of what Dave is talking about? He may be working for a corporation who's spending money, but isn't it a purely voluntary thing that he's working for that organization? If he so violently disagrees with their policy, can he simply not resign and work for someone else?
Dave was talking about it as an investor.
Okay.
Yeah,
someone that
he was
buys
talking
stock.
about it as an investor, and he told me the corporation is publicly traded. He can sell the stock.
I see. Okay.
At the full price today, and that price, by the way, will also incorporate future expectations of value of the corporation. So he's really not going to be a loser. And there are so many options, tens of thousands of investments on the market that it's just not a hardship in today's market.
Okay.
But again, if I could wave a magic wand, I would say, well, real corporations and labor unions should not be participating in politics. But that's different from what the First Amendment provides.
Do you mind if I follow up on that, Rob? Why would you want that? I mean,
Sorry?
why would you want to limit what corporations can do?
Well, I think because I don't like one person spending another person's money on his political stuff. Mm-hmm. I mean, it's even worse when government does it, right?
But corporations...
Government spends money in order to promote particular points of view, and I think that's outrageous. But I also don't care for it much when corporations and labor unions do it, and they therefore force their members to take affirmative efforts to opt out.
Well, no one really likes it, especially when we disagree with whoever's speaking, right? I mean, it's one of the uncomfortable things about living in a free society. But at the same time, corporations, unions, businesses, Peter and John, we're affected by the federal government's decisions and by certain laws that it makes and by our state decisions and certain laws that it makes. And it seems like we should have a place where we can address those. And if we can't address them through, the legislature or whatnot, it seems to me that the polling place is a fully valid way to try to address issues that affect us.
Well, there's an alternative. I mean, remember I said corporations are economic entities. I was talking, of course, about for-profit corporations. The people who are involved in a particular business absolutely can pool their money and form a nonprofit corporation devoted to political activity, and I think that's fine. One of the scary things about positions like Senator Tester is he would also apparently strip away the right of organizations like the NAACP or the National Rifle Association that happen to be incorporated, strip away their right to First Amendment protection. So I should clarify that my remark has to do with specifically economic corporations designed to go out there and earn a profit. On the other hand, it's also true, isn't it, that when you have a government that's grown so large that with one regulation they can put any corporation out of business, it's pretty hard to argue that corporation shouldn't be able to fight back.
Okay, with that, we're going to take a 1-minute timeout. So Roy and Bobby, hang on. We'll get you guys on in a moment. We have one line open. People want to visit with Rob Natelson. We'll be back momentarily. Hey, we're back on Talkback. 721-1290 is the number, and Rob Natelson joining us on the phone from Denver, Colorado. I want to be faithful to our listeners or to our callers. Been waiting a long time. Roy, you've been waiting the longest. Go ahead, sir.
This is Bobby.
Oh, I'm sorry, Bobby. Hang on. All right, so Roy is on 3. My apologies. Roy, go for it, sir.
Yeah. Good morning, gentlemen. This is rather a long question, so please bear with me. Rob, I realize that socialism is a form of tyranny in which, if embraced by us, we will lose our constitutional individual rights and liberty. For years, I've been educating myself and trying to educate my relatives and others about the dangers to our liberty of socialism. Because I know that some people like myself reject it, I believe that if it is imposed on us, there will likely be what I dread the most, another civil war. I look around me and see Mark Levin, my favorite talk show host, as regards educating us on American history and our Constitution, saying we are living in a soft tyranny, and that the socialists now control the mainstream media, the government educational system, and much of our government.
Yeah, no, I had to do this to you, Roy. We are running out of time, so get to your question, please.
Can I continue?
No, you can't.
If you can just ask the question. Please.
Ask a question, please.
Okay.
I know you got a lot written out there, but go ahead.
Rob, do you believe we are on the verge of another American Civil War?
Okay, so thanks, Roy. So what do you think, Rob?
No.
Okay, easy. All right, and let's move on to Bobby. Bobby, you're on Talkback. Go ahead.
Okay, well, unfortunately, Rob's answered just about everything I had a question about. But, every time the thing with the dark money, the Democrats always say the dark money, but they get money from the unions. The teachers' union is actually a government union, and they contribute a lot of money, and regardless of what their members want. And a lot of organizations, you could call them a corporation or organization like, say the Sierra Club, they contribute a lot of money. So I think the Democrats are very hypocritical because if the road runs my way, that's great. But when you want to judge the other guy, well, that's unconstitutional, and those groups should not be an individual. So what's your opinion? Thanks.
Well, yeah, I think it is hypocritical. And let me chide my old friend Jim Nelson, who used to be on the Montana Supreme Court. I mean, I really like the guy, but when he starts talking about dark money and keeping money out of corporate money out of politics, when he was on the Montana Supreme Court, you have trial lawyers giving money to judicial candidates and then appearing before the judges whose campaigns they had financed. I mean, there's nothing more contrary or more suspect than that. So it seems to me, I would agree, a little hypocritical to talk about the ability of people who don't have cases before the court to get together and pool their assets and try to influence campaigns and consider that bad, while allowing trial lawyers who appear before the court to fund the campaigns of justices like Jim Nelson. I mean, that's the conflict of interest there strikes me as a far greater problem.
Hey, we've got about 4 minutes left in the show, Rob. One thing I know that people are going to be asking with this Arizona news, if they do set up a convention of states, is there a chance it runs away and we end up with a new constitution Is this something that's happened in the past? I know the professor from the University of Montana said that that's how our first Constitution started. Anthony Johnstone said that on Talkback, basically, that it was a runaway convention.
Yeah, and I feel for him because I used to believe that as well. But the fact is that the Constitutional Convention had full power to do what it did. The mistake arises because people assume that there was a certain congressional resolution called the Constitutional Convention, and it was called under the Articles of Confederation. That, in fact, is not true. The Constitutional Convention, as I mentioned earlier, was called by Virginia. The delegates were given very broad powers by almost all the states, and they had full power to do what they did. We've had about 40 conventions of states. The number keeps growing. And I've yet to find one that clearly ran away or just disregarded its mandate. Plus, there are a number of court decisions out there which say that a convention is bound by the scope of its call. So it's not really a serious issue. What is a serious issue is if we don't do anything, Congress is going to continue to fiddle or do things worse while the country degenerates. I don't think we're on the verge of civil war, but if it went on for years more, it could produce a civil war.
Now, with the president that we have in office right now, who has been so divisive in so many ways, do you look down the road in your political crystal ball, if you have one? Do you think that relations between President Trump and the Democratic Party and even his own party will eventually improve, or that he will eventually gain the skills to be a good president?
You know, it's really hard for somebody at the age of 70 or 71, which he is, to learn entirely new skills. And if you recall on this show, that's one of the cautions I had about the Trump candidacy. We'd never really had a president before who has had zero political experience and zero federal experience. So whether it's going to get any better, I just don't know. Of course, I hope it does, but I'm not terribly optimistic, but he's fooled me before, so who knows?
From day one, he had members of Congress already trying to impeach him. I don't see how it can't get better. I mean, there's nowhere to go but up.
Well, yeah, but I think that would have been true no matter whom the Republicans elected. The old days of a honeymoon for a presidential candidate are over. And again, this is a reflection of the size and scope and power of the federal government. The stakes are so high. You know, the president can put many businesses out of business with an executive order. Administrative agencies can do the same. You know, back when we still honored the Constitution and the federal government was fairly small, if the federal government did something you didn't like, well, there were plenty of other opportunities. It was sort of like, you know, you could sell your stock in one company and buy another that maybe wasn't regulated by the feds. But today they've got their fingers in everything, from the toilet you buy to the electric lights that you put in your lamps to just about everything. And under those circumstances, every single fight is going to be a fight to the death. If you're looking to get this kind of animosity and partisanship out of politics, you need to reduce the scope of politics, and that means to reduce dramatically the size of the federal government.
And we are out of time, so give us some contact information, how we can read more from Rob Natelson.
Well, take a look at my book, The Original Constitution, What It Actually Said and Meant. It's on Amazon, and you can reach me at robnatelson.com.
All right, Rob, always a pleasure, sir. Thank you.
Thank you.
Take care. All right, Elsie Arnson?
Yeah, we'll be on tomorrow from 8:30 to 9.
Fantastic. You guys have a great day. We will see you tomorrow at 6.